Welcome to the interview where we're digging into esoteric elements of headlines that reveal what's really going on by asking what others are not. The FBI raided John Bolton's home and office as part of an investigation into possible mishandling of classified materials. Officials emphasize the legality and renewal of a former investigation, but critics interpret the timing and context as politically charged. No charges have been made here, by the way. Joining me now is Mark Zaid, an attorney who has represented covert spies, federal workers, and members of the intelligence community. So, Mark, thank you for joining us. Let's start with the primary question here, which is this politically motivated, or does the judicial oversight legitimate what has happened here?
Well, I think, and thank you for having me on, I think the answer could be yes to both, quite frankly. And we're going to have to wait to see as time goes on. If this had happened 5 years ago, I would have perfectly understood it. The timing of it makes it highly, highly suspicious that it's political. But that doesn't mean there's not a legitimate legal basis to actually pursue this investigation. And we could obviously go into more details about that.
Yeah, so, you could think about jurisprudential sort of prior restraint here, and you could ask yourself whether or not that's been fairly applied. And why now? Why now? Does the timing strike you as very odd?
Yeah, that really is the $64,000 question as to why now. What did Bolton do? Especially if it turns out, once we hopefully see the warrant as well as the FBI supporting affidavit, if it has to do with his book, Inside the Room, from back in 2020, then that's incredibly suspicious. Why would they have waited all these years? If it has to do with something more recent, and it's possible, obviously, Bolton goes out on the media, print and television, radio all the time, commenting about things and topics of which he once had access to classified information. I've been warning for many, many months that I predict there will be some Espionage Act prosecutions against journalists or former intelligence officers, senior officials who have fallen out of favor with Trump because the statute allows so readily for abuse. It is so broad. And when I say Espionage Act, I'm not talking about spying, not talking about that they're a spy for an enemy power or anything like that, or even a friend. The Espionage Act covers dissemination of national defense information, transmission, as the statute says, because the statute dates back 100 years, hasn't been amended since the Korean conflict in the early 50s. Transmission of national defense information, and that could be whatever the executive branch, frankly, says it is. So there could be a whole host of things that Bolton is potentially facing, but we need to see more about what justified this FBI search so we can assess whether this was politically vindictive or actually has a legitimate basis, or both.
What about non-disclosures? Likely there would have been some of that in the mix with Bolton. And, it seems as though it could be kind of considered as quasi-fiduciary restraint here, in that the Supreme Court has looked at non-disclosure agreements, not necessarily as completely suppressing your First Amendment rights. And so Bolton could have some claim under the auspices of that concept. Do you think that he could rely on that? Is there an over-reliance on non-disclosures, you think, by the government? And will the Trump administration maybe use that to go after Bolton?
So with respect to those of us who have had security clearances, we sign secrecy non-disclosure agreements, and there are multiple versions of it. And Bolton would have signed ones that apply to secret, top secret information called an SF-312. People can Google it. Or a 4414, which is the SCI, sensitive compartmented information. That document has a pre-publication review requirement. And the courts have held numerous times. I litigate these cases regularly in representing former senior and even junior officials of the U.S. government, whether they served in the military or the intelligence community, or even secretaries of defense and national security advisors I've represented, in trying to get their books cleared so that they don't have classified information in them. courts have upheld the non-disclosure agreements in those contexts. But there is a First Amendment right to publish non-classified, unclassified information. When in the first Trump administration, the Trump Justice Department went after Bolton, they did it a strange way, and a way that was doomed to fail. One, they first went after him for an injunction too late to stop the book, and they only went after him instead of the publisher. But even then, they wouldn't have succeeded, because that's the Pentagon Papers case about the New York Times and the Washington Post from back in 1971. There's a high burden that the government needs to meet to be able to enjoin someone from disclosing information even when classified. But that doesn't mean that the disclosure is not criminal or breach of contract with respect to Bolton's case. They continued that litigation, and in fact, a federal judge said that he was persuaded there was classified information in the book. But they didn't continue it far enough or fast enough. And then, of course, Trump lost. Biden administration came in, and both the criminal investigation was dropped, as was the civil lawsuit.
Yeah, and the ruling, and stop me if I'm wrong in this, but the issue was that there wasn't enough judicial power to get the book, destroy it all, that would have been overreach. Is this, I mean, we don't know because we haven't seen the affidavit or the warrant, but I have to assume that John Bolton has lawyered up and that his lawyers are looking at that as potential overreach, not from the judicial perspective, but now from the FBI. Do you see that? Yes or no?
So here's where Bolton could be in real trouble. And there's a grave difference, significant difference between trying to get an injunction to stop publication, which was just too late. Although I've had cases where we made arrangements with the government that the publisher pulped, destroyed 50,000 copies of a book because they were concerned it had classified information, and the government actually reimbursed St. Martin's Press for that destruction, and then the book went forward with a cleared version. Where Bolton has potential liability, if this is about the book, is people don't realize that when someone is drafting their book to be published about whatever they saw and heard and analyzed, what do they normally do? They give copies to their literary agent, to their publisher, maybe to their lawyer, and those people give it to many other people. So when John Bolton, and most of the time when people come to me for their books, they come to me at the time when either right before they submit it to the government for pre-pub review, or after the government has taken too long and I'm going to sue them to try and speed up the process and get the book cleared. So when John Bolton submitted the book to the White House for review to a career professional, that career professional told the judge in his injunction case that the book contained a voluminous amount of classified information. And they then spent several months negotiating the text back and forth, which is quite common, until it got to a point where she believed the book was unclassified. And then a political battle took place where lawyers in the White House stepped in to say, nope, it's still classified. Okay, push that aside. The submission of the book contained voluminous amounts of classified information. And that draft copy was no doubt submitted to multiple unauthorized third parties that Bolton was connected to. Those are all violations, not only of his secrecy agreement, but also of the Espionage Act. Now, that happens all the time. You look at any cabinet officer who has written a book, any mainstream book that deals with the intelligence community, that is how the process has always worked logistically, because it's just not feasible for someone who usually can't write well to then write the book, submit it, and then go to a literary agent and a publisher. And the policy and practice has been for 50 years that as long as the government had the ability to ensure that when the book was published, when it was available to you and me, that they would be okay with the fact that technically, on paper, realistically, there have been violations of the law. That's the trade-off. But if the Trump administration wants to reverse that norm, because it's a norm, the law would allow the Trump administration, to go after John Bolton if the facts as I've described them are true, and I dare say they probably are.
But can we look to the June 2021 conclusion of the Biden administration that there was no wrongdoing here, calling it a complete vindication, and that means that this additional probe would necessarily be proved deficient because the case was closed and it was dismissed with prejudice? That seems like a lot of cover for John Bolton. Why haven't his attorneys already tried to get an injunction against the seizure of these documents?
So I'll take it at your word, because I don't remember if the civil case was dismissed with prejudice. But if it was, that would preclude the government from reviving the civil lawsuit for breach of contract. And it wouldn't surprise me if that was the case. In fact, I criticized the Biden administration for dropping the civil lawsuit.
And the criminal investigation was dismissed with prejudice, which is obviously what the Biden administration under the Department of Justice was investigating at the time. And because of that,
I don't think so.
Wouldn't that fall? Isn't that what would fall under the auspices of this kind of FBI probe?
The investigation was closed. There was never any charges brought against Bolton, so there was never anything that was dismissed with prejudice. So as far as I know, the criminal case can be revived. And I would imagine that the reason why the criminal case was dropped at the time was because of this description I just gave as to the normal pre-publication review process. Because although, as well as it being incredibly political and in a bad way, all of the political parts of the bad way, and the Biden administration's at fault too. But to have brought that criminal case against Bolton would have opened such a Pandora's box. Now, it may be a legitimate one, and this is what I've constantly said for 5 years. In fact, in the civil lawsuit that they brought against Bolton, there was a declaration, a sworn declaration filed by the then National Security Agency Director, Paul Nakasone. He's not a political person. He was a general who was running the NSA, and he said in his sworn declaration that, in fact, there was SCI information in the manuscript. That is the highest level classification level that there can be. And that has never been addressed by anyone because both the civil and the criminal cases were dropped. And so that's still out there. And this is why I say, for a number of reasons, Bolton could have potential liability, but that doesn't mean this search was not political.
So if there's any investigation that can be triggered by some sort of political animus, if it's real or perceived, what does this say about our Department of Justice? A lot of people have looked at this and said this is clearly retribution. This is clearly about going after those who are political foes, again, real or perceived. Does the perception here of the Department of Justice become one in which the American people really can't have faith?
Well, it used to matter. The perception and appearance of the rule of law and ensuring that what happened at the Justice Department was separate and apart from the White House, that used to matter. You did not see senior government officials commenting about these types of investigations. You would not have the FBI director live tweeting about it, the attorney general live tweeting about it, the vice president and president of the United States making comments that are prejudicial to the individual alleged suspect. They would normally always, and it's a norm, defer to the Department of Justice. And there's a spokesperson, obviously, at the Department of Justice who would say, this is an ongoing investigation, I can't comment, et cetera, et cetera. That was how it was always done until the second Trump administration. This is how it was done in the first Trump administration for the most part. So, yeah, I think when you have the FBI director who would have signed off on this, having put John Bolton on an enemies list in his 2023 book, having comments made by the President of the United States that John Bolton is a criminal, a sleaze, a slime, whatever else he's saying he deserves to be in jail, that is problematic, and it erodes at our sense of democracy and the rule of law. And I am, you introduced by saying I represent spies. And I do, other than my clearance has been revoked by the president too, so I can't do it in the way I used to. But in representing spies, American spies, our spies, people who work at the CIA, the disclosure of classified information unauthorized presents grave threats to my clients. It could lead to the death and harm to the life of one of my clients. I take that incredibly seriously. So anyone who leaks classified information, who doesn't follow the rules, there should be consequences for that individual, whether it's civilly or criminally. And it doesn't matter with respect to politics. But my view, yes, we are seeing vindictive retaliation and retribution by this administration. I don't even think it has to be that it's my view or others. They say that it is. They've telegraphed it from day one what they were going to do, and they're doing it. So I guess kudos to them for actually standing by their word.
Should Congress have some sort of formal statutory overview for how classified documents or access to classified documents comes about? And they have historically declined to do that, and maybe that would provide some clarity so that the executive can't function sort of as like a shadow Supreme Court in some ways through the judiciary. Every time there's one of these issues that comes up or questions about access to classified documents or improperly handling classified documents, that there is some sort of statutory framework so we have more clarity about this. Should Congress step in and make this much more clear?
This has been a debate for many decades, and there have been instances where Congress has stepped in. There are separation of powers issues and concerns under the Constitution for which branch of government controls the information, but there is a sharing amongst the three branches. The Freedom of Information Act, passed in 1966, grants the ability of individuals like you and me to challenge classification decisions. And in the Ford administration, there was a decision by a judge to release information, and the executive branch refused. So Congress modified FOIA, amended it to make sure that the judiciary had oversight to make decisions regarding whether or not a document was classified. And actually, President Ford vetoed it, but Congress overturned the veto. So it has been law for the last 50 years that the judiciary can overturn a classification decision of the executive branch. And there have been other examples like the John F. Kennedy Records Assassination Collections Act. There have been Nazi records, Japanese records that have all been declassified by statute of UFO records by Congress. But generally speaking, they have tried to stay away from that fray. I think there could, in a Congress that wasn't as polarized as it is now, as political as it is now, there are statutory ways in which the process could be balanced better to allow for classification type challenges. For example, under the Espionage Act, when the executive branch makes a decision that a document is classified, it's not a defense to be able to challenge outright by that defendant that it has not been properly classified. That has been something that has been discussed for decades to try and modify. But actually, because of the polarization I've mentioned and that everybody sees, I would never want Congress to jump into this fray right now because it's just going to honestly make it worse. And this is a statute that has not historically been used very much. And I'm hopeful it's not going to be used very much in this administration, but that will be something time will tell.
Yeah, the politics are one element of it, but you described basically a piecemeal. So that isn't a comprehensive statutory framework. And I'm wondering if there is an environment, if we could ever even get to a political environment, where there could be legitimate debate about this so we don't have to come back to this again, seemingly all the time, where, again, the judiciary is sort of functioning as the arbiter here in every single case. And there's no, as you mentioned, because some of these standards are so broad and can be interpreted in so many ways, they are easily used as tools to go after your political foes. Do you see an environment in which Congress could come to a place to make this more standard?
I think there could be. I don't know when that necessarily might be. That's the problem. And look, I dare say, and I've been predicting for months, I think the Espionage Act is going to be used against your peers in the media. There have been a number of journalists who have already been called out by senior Trump administration officials. And we know that, entities like the Wall Street Journal, the New York Times, Fox News at times publishes classified information in their stories illegally because there is no First Amendment defense. There is no reporter shield privilege. And I represent journalists all the time, including giving advice on how to deal with classified information. And there is a risk here. And the problem has been it's more in the hands of the executive branch, unfortunately. Judges have always shown deference on national security decisions to the executive branch. And that's probably a good thing, but only when the executive branch maintains sort of, if you think of a bowling lane, stays within the lane. If you put the bumpers up and it doesn't make a difference if you throw it to the left or throw it to the right because it's going to bounce back and forth and ultimately go hit some pins, then we have a problem. And that's where I think we are with this administration. We're early on, and we don't know how bad it could get, and hopefully it wouldn't be, because hopefully they will stick by a lot of the norms. But the parameters are there under the law. For example, for anyone who once held a security clearance and speaks as a talking head on any television network, ostensibly the executive branch could say that what they said they learned through their work in the cleared environment and was a violation under the Espionage Act. And while maybe they wouldn't be convicted, maybe that criminal case wouldn't go to a trial, depending on a number of factors, the mere fact of indicting someone, charging someone for that person is going to be a massive deterrent. And for everyone else who might want to go, I don't want to be in that situation. So whatever happens to John Bolton, the message itself has been sent that those of you who criticize the President of the United States and might perhaps have crossed the line with respect to the classified information, that we will make an example of you. Because I can tell you, it is not a fun thing to be or bear the brunt of the weight of the U.S. government, whether it's whichever branch, but certainly not, under indictment, regardless of what the outcome might be.
Yeah, and we have to talk about the Mar-a-Lago raid. A lot of analysts have looked at this and said, if you could shatter the insulation of Article 2 protection and go after a former president and raid his estate, then the DOJ has come to a point where really anybody could be subject to this, and that we sort of laid the groundwork for continued questions about classified documents because of that. And maybe that went too far. Did it go too far in your estimation?
No, I don't think it did. And the notion is, under the rule of law, everyone is the same. Thomas Paine, when he wrote in Common Sense 250 plus years ago, talks about how the rule of law applies to everyone. We don't have a king. Now, the Supreme Court has given enhanced immunity to a president of the United States, so there will be less opportunities in the future, unless they reverse that decision or modify it, for an executive branch to go after a sitting or former president. But if you look at the facts of the Mar-a-Lago situation, and I always stay away from the term raid. I don't like the term raid. They conducted a lawful search. The Mar-a-Lago search was signed off by a federal magistrate judge, as was the search of John Bolton's home. Either you think that that process works or you don't think. One of them can't be a raid and the other not, and one of them can't be improper and the other not. They were both through the process. Now, the motivations and what evidence, underlied getting the warrant, that's a separate issue. But the federal judiciary aspects of it is the same. So for Mar-a-Lago, you have to understand what the facts of the situation were. Now, there have been many, many presidents who have taken home documents to their presidential libraries and store them and things like that. And there have been problems. Obviously, we saw it with President Biden and we saw it with President Trump. Normally, that would never happen because there would be such a thorough process beforehand. It starts months and months before a president leaves office to talk to the National Archives and other experts to make sure what documents are you going to retain, what is not classified or what is. And, presidential libraries have classified records in them. They are allowed to properly store them and secure them. So that's fine. But President Trump just took all these boxes of documents. And when the National Archives realized it, they engaged in a back and forth that extended for something more than a year, if I recall correctly, a year and a half. And President Trump would not release the documents. And understand, they also had internal sources, the government did, where people came forward and described what they had. They got a hold of video footage. Individuals were lying about what they had. I mean, there was a lot more fire than smoke behind the President Trump's Mar-a-Lago case. And I've represented individuals who have faced charges for far less than what President Trump did with the classified documents. So if anything, that case I thought was the most rock solid out of all the cases that anyone brought against President Trump. And we can absolutely debate whether some of those should ever have been brought in the first place. But looking at Mar-a-Lago, he was held to the same standard all of us are, that we are not allowed to retain classified information in non-secure facilities.
All right, my final question here is about generally the expansion of the executive into the national security domain here with this raid or search warrant execution, however you want to describe it. And since we are talking about some of the founding ideas, does it comport with the Madisonian idea of institutional jealousy instead of this investigatory zeal all the time, so that people who serve our government and are privy to classified information, that they can live their lives afterwards? I mean, we need people to be able to feel like they can serve our country and then not necessarily be subject to arbitrary and capricious searches, if that is what this is.
No, I mean, certainly phrased that way 100%. And generally has not been an issue. I mean, just look back historically, in the last 40 years about when are there individuals who are targeted or prosecuted after they've, other than when they've improperly retained classified information, like John Deutsch, the former director of the CIA in the Clinton administration. He was found to have retained information at his home following his service as CIA director. Not allowed. I just blanked on his name, but former national security advisor for President Clinton, who went to the National Archives to look at classified records and literally stuffed them in his socks and ran out of the building and got caught and got prosecuted for it. Most people follow the rules. And so when people come to me to write their books, we go through the process. We let the federal government, whichever agencies, do what they need to do to assess if there's classified info. And if they don't finish the review in time, or if they say something is classified, we don't do as John Bolton did, which is rush to publish. No, we litigate the case. We file the lawsuit and we challenge the executive branch's decisions. I did that with former Secretary of Defense Mark Esper. Yeah. I did that with former Acting Secretary of Defense Mark Miller as well. Chris Miller.
Or we're right there at the end, and I hate to wrap you up there, but they're giving me that cue. Listen, I appreciate your information here and your analysis so much. Thank you, Mark Zaid, for joining us. I really appreciate it.
Thank you, Hilary. It's my pleasure.
Thank you.